Good morning to everyone. I would like to first introduce you Professor Valentine Bonini. She's from University of Pisa. She's a professor at criminal law at the Faculty of Law at Pisa. Also, she's main research focus area is criminal procedure law. Also, she works on the topic on issues on domestic violence issue, many things related in this concept. And also she's a part of and member of the European Law and Gender Action. This is a Jean Monnet project and cover the topic on domestic violence and gender-based discrimination violations. It's an interdisciplinary project. The main goal is to promote the achievement of innovative teaching, training, practices, a policy recommendation, and also it includes a variety of subjects, public and constitutional law, private law, criminal law, and also use many different methodologies, including comparative law, legal theory, and psychology of law. This is a European Union project dedicated at gender-based violence and discrimination, and Professor Bonini is one of the founder and the participant of this project. So we are very happy and honored to guest Professor Bonini here, and today she will talk about the positive obligation of the state in terms of women domestic violence and gender-based violence in a time of COVID-19 period. So Professor Bonini, the microphone is yours. Happy and glad to be you are here.
Thank you. Good morning, and thank to all of you here. I am absolutely honored to participate to the summer school Law on the Bosphorus, and want to express my gratitude to Professor Adam Souza and to you, always so polite and precious, Rahime. My gratitude for involving me in this very interesting experience. We are here in this virtual location to make some reflection about gender-based violence and human rights. I would like to share my presentation. Can you see it? Is it okay?
Yeah, it seems okay, Professor Bonini.
Can you see it, Rahime?
Yes.
Okay. Yes, it's working. Okay. Only a few decades ago, the juxtaposition of gender-based violence and human rights in many social contexts may have seemed somehow risky and maybe eccentric. Many acts of gender-based violence were yesterday an expression of a normal hierarchical relationship between women and men. And the intertwining of culture, society, and violence against women was clearly visible also in the words of the law. Having regard to Italian experience, I'm thinking about murder for reasons of honor under Article 587 of our criminal code, or to the rape and sexual violence as a crime against the good repute, which was not punished if followed by wedding between the perpetrator and the victim. These were our legal provision until 1981. Moreover, sexual violence as crime against public morality and not against the person and the personal liberty has been enforced in the criminal Italian system until 1997. Violence against women was commonplace, tolerated, and to some extent excused by the society and by the law. So nothing further from protection of human rights. Today, we are meeting here to talk about gender-based violence as a part of a program.
Rahime, what happened? She can try again.
Can you hear me?
Yes, we can hear. Now we can hear.
There was a problem of connection.
Yeah, okay.
Okay. Unfortunately, we have not a good weather today. I hope I can go on. I was saying that our starting point.
Sorry, just a moment. Anlattığı konuyu bir daha tekrarlaması gerekir mi Rahime? Duyuldu mu?
Duyuldu hocam da slaytını tekrar ayarlaması gerekecek. Slaytı gitti. Onu söyleyeyim ben hemen.
Peki Berk, sen de aynı fikirde misin? Tekrar etmesine gerek var mı?
Bir sorun yok.
Okey. Slaytını şey yapsın o zaman.
Okay. Professor Bonini, could you share your screen again?
Okay.
Okay, great.
Okay. I was saying that our starting point is that gender-based violence is a violation of human rights. This is our starting point, but not a foregone conclusion in the light of some recent political trends. In any case, the assimilation of gender-based violence to a violation of human rights is made clear by various international documents. The Convention for the Elimination of all forms of discrimination against women of 1979, whose Article 1 says the term discrimination against women shall mean any distinction, exclusion, or restriction made on the basis of sex, which has the effect of purpose of impairing or nullifying the recognition, enjoyment, or exercise by women of human rights and fundamental freedom.
Professor Bonini, we can't hear your voice.
Identified.
Professor,
A clear identification of gender-based violence as a violation of human rights.
Yeah, Professor Bonini, could you repeat your last sentences because your connection is broken?
May I try? Can you hear me?
Yes.
Okay, maybe the connection is not stable. May I try not to use the screen sharing.
Okay.
And maybe we can, you can hear me, okay?
Okay.
I sent you the slides, and you can share it with the students. But we try just to speak, not using the share, the screen sharing. Okay.
Okay.
So I was saying that a clear identification of gender-based violence as a violation of human rights is highlighted by Article 3 of Istanbul Convention on Preventing and Combating Violence Against Women and Domestic Violence. Here we can read that violence against women is understood as a violation of human rights and a form of discrimination against women. In the Istanbul Convention, we find not only a definition, a useful definition of gender-based violence, but clearly there is expressed that it is a violation of human rights. The same result is also achievable through the analysis of the Courts of Human Rights case law. European Court of Human Rights case law deals with gender-based violence under Article 2, right to life, Article 3, right to human treatment, and Article 14, against any form of discrimination. And in this perspective, we can say that gender-based violence is a violation of human rights because it attacks the right to life, the right to human treatment, and because it's a form of discrimination being acted against women for the reason that they are women and being acted disproportionately against women. Very similar is the case law of the Inter-American Court of Human Rights, dealing with gender-based violence under Article 4 of the Inter-American Convention of Human Rights, right to life, Article 5, right to human treatment, Article 7, right to personal liberty, having regard to the obligation to respect rights under Article 2. Gender-based violence is not only a form of violence that harms directly the right to life and the right to human treatment, but it's a violation of human rights in itself because the violence against women is a form of discrimination that seriously inhibits women's ability to enjoy rights and freedoms on a basis of equality with men. This equation, the equation between gender-based violence and violation of human rights, has a strong symbolic value because it gives autonomous importance to gender equality and suggests holistic interventions which operate both on the social, cultural, and juridical level, asking for specific criminal provisions too. In particular, the Istanbul Convention focuses on the multiple intervention plans, asking the states parties to implement global and coordinated policies to reduce all forms of violence against women. It is more important today to underline the symbolic value of inscription of gender-based violence in the area of violation of human rights because, as you know, we are living a political season that after several years of positive implementation sees some countries, Turkey included as well as Poland, demanding to withdraw or in other countries not enter, refusing ratification, to withdraw from the Istanbul Convention because it's seen as a threat to the traditional family structure. Actually, I guess that the protection of a family in its traditional dimension and in its unconventional forms cannot be achieved without first protecting people who are part of a family in an equal position. And this is what Istanbul Convention aims to realize. Furthermore, the identification of gender violence with a violation of human rights has important legal effects because it gives rise to specific obligation of the state parties which derive from Articles 2, 3, 14. And from this point of view, the European Court of Human Rights has had a very important role building a protection against gender violence through a system that revolves around the Articles 2 and 3 of the European Convention, and Cara Chioni will analyze in depth this case law. So briefly, and with the only intent of a quick introduction, I can recall how the protection of human rights imposes a series of obligations that have both a negative and a positive content. The former, the negative obligation, requires states not to behave in a way that results in violation of fundamental rights. The latter, the positive obligation, requires states to adopt active behaviors, actions that protect fundamental rights from possible violation by third subjects. I can recall the decision of the European Court of Human Rights, Osman versus United Kingdom of 1997, where the court notes that the first sentence of Article 2 enjoins the state not only to refrain from the intentional and unlawful taking of life, but also to take appropriate steps to safeguard the life of those within its jurisdiction. Regarding to positive obligation, the European Court charged states to promote active policies that punish attacks on fundamental rights and that ensure an effective judicial response to victims. And these ones are the procedural obligation. Just to recall, the leading cases in the matter of gender-based violence, in the case of Opus versus Turkey of 2009, discussing about a violation of Article 2, the court highlights that the positive obligation involves a primary duty on the state to secure the right to life by putting in place effective criminal law provisions to deter the commission of offenses against the person. By this way, penalization duties arise, to which are added obligations of effectiveness of a proceeding. Criminal law is implemented through trial. Thus, criminal law is not sufficient to itself, needing a speedy and fair trial to be applied. The protection of fundamental rights is sought through the dissuasive function of a criminal precept, which needs to be convincing, not only proportionality, but even rapid and effective trials. There is a sort of necessary instrumentality between criminal law and criminal procedure in this system built by the European Court. So, again, in the case Opus versus Turkey, the court observes that the obligation of the parties under Article 1 of the Convention to secure to everyone within their jurisdiction the rights and freedom defined by Convention, taken together with Article 3, requires states to take measures designed to ensure that individuals within their jurisdiction are not subjected to torture or inhuman or degrading treatment or punishment, including such ill treatment administered by private individuals. Children and other vulnerable individuals in particular are entitled to state protection in the form of effective deterrence against such serious breaches of personal integrity. In order to reach that effective deterrence, we need criminal provision and timely proceedings. The essential purpose of procedural obligation is to guarantee the effective implementation of the domestic laws safeguarding the right to life and the right to human treatment. In this sense, gender-based violence has represented and still represents one of the fields in which the CART has sown and reaped the most important fruits of a reflection that aims to build an articulated protection in favor of victims of crime. As known, the European Convention does not expressly deal with procedural rights of victims of crimes. As Article 6 identifies a notion of due process cut out exclusively on the figure of the accused, it is precisely through the positive obligation that a system of judicial protection of a victim is built, starting from the substantial provision of Articles 2, 3, and 14. But which are the procedural obligations? Procedural obligations were introduced by the European Court of its case law, and they were first formulated in the context of use of lethal force by state agents, where the court held that a general legal prohibition of arbitrary killing by the agents of the state would be ineffective in practice if there existed no procedure for reviewing the lawfulness of the use of lethal force by state authorities. The court underlined that the obligation to protect the rights to life, read in conjunction with the state's general duty under Article 1 of the Convention, requires by implication that there should be some form of effective official investigation. Thus, procedural obligations arise from the states, for the state's parties as a result of a specific violation of fundamental rights. And there are their mainly feature are that the judicial authority must be independent, and this is an important characteristic when, a more important characteristic when a public authority is involved as author of crime, as perpetrator. The investigation must open promptly and go on with reasonable expedition. The court considers that a prompt response in investigation is essential in maintaining public confidence in the adherence to the rule of law and in preventing any appearance of impunity. Furthermore, the passage of time not only could undermine an investigation, but also compromise definitively its chances of being completed. Again, the investigation must be conducted properly, with adequacy. The authority must take whatever reasonable steps they can to secure the evidence. And the investigation must be conducted publicly, in the meaning of accessibility of the investigation to the victim or to the next of kin. In one word, investigation must be effective. As pointed out in the case Talpis versus Italy, another leading case in gender-based violence, the mere passing of time can work to the detriment of investigation and even fatally jeopardize its chance of success. The passing of time will inevitably erode the amount and quality of the evidence available, and the appearance of a lack of diligence will cast doubt on the good faith on the investigative efforts, as well as drag out the ordeal for the complaints. Many are the occasions in which the court has underlined the duty of timely and effective investigations and proceeding. In the case of Opus versus Turkey, the court reiterates that the positive obligation laid down in the first sentence of Article 2 require that an efficient and independent judicial system should be set in place. A requirement of promptness and reasonable expedition is implicit, the court says, in the context of an effective investigation. And even in the case Talpis versus Italy, the court recalls the effectiveness of criminal investigation, the promptness, the reasonable expedition of the investigation, and concludes saying that the state's obligation under Article 3 of the Convention will not be deemed to be satisfied if the protection afforded by domestic law exists only in theory. Above all, it must also operate effectively in practice, and that requires a prompt examination of the case without unnecessary delays. This attention for the effectiveness that always characterized the European Court of Human Rights decision is the base to set the procedural obligation. Prompt and complete investigation is a condition for effective protection of human rights that are formally implemented by criminal provision. Following the commission of a crime that affects a fundamental asset, the state has a duty to take action, carrying out timely and effective investigation. Procedural obligation related to investigation are the base not only for the effective implementation of criminal provisions, but also for in order to reach an effective protection of the victim. So arises a procedural obligation to protect victims. The court highlights the connection between timely and effective investigation on one hand and protection needs of victim on the other hand. In fact, it is observed how the slowness, the ineffectiveness of the judicial measure initiative creates a context of impunity, favorable to the repetition of violence. And this is particularly true in the area of gender-based violence, where impunity may give rise to the belief that violent acts against women are socially accepted, tolerated. In a very similar perspective are placed the decision of the Inter-American Court of Human Rights. Emblematic is the case of Ciudad Juárez. In the case is Gonzalez versus Mexico, and has regard to many rapes and murders of women occurred in Ciudad Juárez in the 90s of the last century. And the Inter-American Court observes that these murders of women had different causes with different authors in very distinct circumstances and with diverse criminal patterns, but they all were influenced by a culture of gender-based discrimination. And the court observed that these crimes have remained in impunity, principally from 1993 to 2003, owing to the serious omissions made by personnel of the Office of Attorney General of the state of Chihuahua. And it have been reported many failures during the proceeding, delays in starting investigations, slowness of investigation, or absence of activity in case files, negligence, irregularities in gathering evidence and conducting examinations, and in identification of victims. Moreover, at last but not least, the Inter-American Court for Human Rights underlines the failure to consider the attacks on women as part of a global phenomenon of gender-based violence. And the court, at the end, in its decision, not only convicted the state party for the violation of Article 4, right to life, under Article 1 of the Inter-American Convention that provides obligation to respect rights, but considered that it was pertinent to the state to erect a monument to commemorate the women victims of gender-based murders in Ciudad Juarez. So clear in this decision is the intertwining between cultural aspects and criminal prosecution and punishment in the purpose of contrast to gender-based violence. And now we have a system of positive obligation that the Court of Human Rights have built in the light of the connection between gender violence and human rights, but it has found a more precise definition with the principles and the instruments provided by Istanbul Convention that is known as the 4P system. The 4P in the convention are prevention, protection, prosecution, punishment. Protection and prosecution are procedural obligations that are strictly connected. And protection appears under Article 18 among the general obligation. Parties shall take the necessary legislative and or other measures to protect all victims from any further acts of violence. Particular attention is reserved to effectivity of protection measures and to the aim of avoiding secondary victimization, which occurs not only in case of repetition of the offense, of course, but even when the victim suffers further harm due to the manner in which institution, as well as police, judicial authorities, or other individuals, such as lawyers during the proceeding, deal with the victim during the proceeding. In both cases, legal provision are not enough to satisfy the obligation when other measures are needed, such as state economic efforts, effective organization between public authorities and support services, and so on. Access to protection is not only judicial. Article 22 of the Convention, of the Istanbul Convention, provides the right to especially support services that can be reached by dedicated telephone helplines operating statewide and round the clock, 24 hours a day. Support services and hotlines are used as access to protection, but also as access to justice, because they can be important in order to move a first step toward submitting a complaint. Strictly procedural obligations are provided in the Istanbul Convention under the Article 49 and forward as general obligation, where the connection between proceeding and protection is pointed out. Many principles relate to the investigation, but they operate throughout the entire proceeding. Thus, Article 49 asks to ensure that investigation and judicial proceeding are carried out without undue delay and that the investigation are effective. The needing of a prompt and effective judiciary action is underlined in other provisions, such as Article 50, where it's provided to ensure that responsible law enforcement agencies engage promptly and appropriately in the prevention and protection against all forms of violence, including the employment of preventive operational measures and the collection of evidence. Undue delay or failure in the conduction may create a lack of protection for the victim. Investigation also have the objective of the aim of assessing the risk of repeated violence in order to manage it within a coordinated frame of safety and support actions. This action could see the intervention of shelters, services for the victims, or other measures such as protection orders and bearing orders, so that the perpetrator has to leave the residence of the victims, the home that shares with the victim, and cannot contact the victim anymore. Article 53 provides that protection orders must be available to victims for immediate protection. In Italy, for instance, are operating shelters managed by anti-violence centers intended to welcome victims and their children in order to protect them from an imminent risk of a repeat of the crime. Moreover, we have protection orders that remove accused from the family home and forbid him to approach the victim and the places frequented by the victim. The protection orders can be prescribed as a precautionary measure by both the civil and the criminal judge, and in the event of flagrant crime, even by the police, albeit temporarily. During the proceeding, victims have not only a right to protection, but even procedural rights to quick and complete investigation. And in this frame, victims have a right to be heard, to supply evidence, and have their views, needs, and concerns presented and considered under Article 56 of the Istanbul Convention. This broad, solid, and detailed set of procedural faculties and protection rights is necessary to protect the victim and to effectively pursue actions related to gender-based violence. Are these provisions about human rights protection enforced during the pandemic emergency? Yes, they are. Relating to the European Convention of Human Rights, let me remind that European Court of Human Rights in the case Talpis versus Italy underlined that Article 3, like Article 2, must be regarded as the one most fundamental provisions of the Convention. And in contrast to the other provisions in the Convention, it is cast in absolute terms without exception or proviso, or the possibility of derogation under Article 15 of the Convention. Having regard to the Istanbul Convention, Article 2, paragraph 3 expressly provides that the Convention shall apply in times of peace and in situation of armed conflict, letting us understand that any suspension is allowed, no suspension is allowed in times of peace and in times of crisis too. In this direction goes the declaration of the Committee of the Parties to the Council of Europe. The Committee of the Parties issued a specific declaration the last April 20 on the implementation of the Convention, of the Istanbul Convention during the COVID-19 pandemic. And in this occasion, the Committee of the Parties recalls that the principles and the requirements of the Istanbul Convention provide a framework which applies at all times and takes on further significance under the ongoing public emergency caused by the outbreak of COVID-19. The obligation we have spoken about not stop in times of emergency. This is an important affirmation. We stigmatize the lack of gender sensitiveness of the policies adopted in response to pandemic. After all, generally, human rights need to be defended more carefully in time of crisis. And in the same way, violence against women and girls, as well as domestic violence, tend to increase during every type of emergency. The data collected for now partially by public agencies and non-governmental organizations highlight a generalized increase in domestic violence in the period during which the virus containment measures were applied. The lockdown and the confinement measures are not the cause of violence, of course, but they favor an increase in family stressful situation that can lead to acts of violence, psychological, moral, physical violence. Exacerbating factors include worries about security, health and money, cramped living conditions and crowded homes, isolation with abusers, movement restrictions, deserted public space. So we have an increase of domestic violence, of online violence too, with more people spending time online. This form of violence, such as revenge porn, are likely to increase. The spike of domestic violence, gender-based violence and child abuse is due to movement restrictions, loss of income, isolation, overcrowding, and so on. And this is not surprising. Previous epidemics, such as Ebola virus disease outbreak in Africa, led to regional measures where domestic violence became more prevalent. The problem is made more serious because the increase of gender-based violence episodes collides with a decrease in support services for victims, the impossibility of accessing shelters, the difficulty of accessing health facilities, and the suspension of legal activities. The lockdown and the social distancing measures had a strong impact on the availability of support services, on the access to justice in order to present complaints, and on the access to immediate protection by the shelter, accommodation, or by protection orders. The virus containment measures, on the one hand, increase the violation of fundamental rights perpetrated within the home, and on the other hand, inhibit or severely limits the possibility of accessing essential services such as healthcare, assistance service, and justice. So what have the states parties to do in order to ensure an effective response to gender-based violence in time of COVID-19? National response to COVID-19 must include, regarding access to justice, that women should be allowed to leave home during the lockdown if they are living a situation of domestic violence. And we need awareness about it. During the confinement measures, any deadline for filing a complaint must not expire. And it's necessary to ensure that civil and criminal cases, such as protection orders in case of domestic violence, are classified as urgent cases by courts that have restricted operation due to emergency measures. Justice service is essential and no suspension should be allowed. Investigation must be regularly conducted in order to collect the evidence and assess the risk of re-victimization. The trial can be celebrated in the respect of social distancing measures, reserving remote participation by technological tools for those cases where the victim has specific protection needs. In order to properly react to the challenges that pandemic generates in the contrast to gender-based violence, we have to go back to our starting point. Gender-based violence is a human rights violation due to a discriminatory approach of a relationship between women and men. The pandemic is an emergency, but gender-based violence, unfortunately, is not an emergency. And needs stable, solid, consistent prevention and counteractions operating in everyday life and during the crisis. We cannot stop proceedings and we cannot stop protection from gender-based violence without implicitly legitimating human rights violation. That's what we have to do even in these our new normal during and after lockdown and confinement measures. And I want to thank you and thank the Law on the Bosphorus Summer School for doing it. Thank you very much.
We thank you, Professor Bonini. Thank you so much for this, your excellent presentation. This is topic positive obligation of state, especially in terms of COVID-19. It's really big topic and serious topic. And as a key speaker, you could show us very remarkable grounds. I'm sure Kara will elaborate this some point, but thank you so much for this complex and very important topics.